Section 33 of the Canadian Charter of Rights and Freedoms is known as the notwithstanding clause. It's one of the most controversial parts of the Canadian Constitution. Conversations about how the provinces use that clause are heating up, especially here in Saskatchewan. It's even caught the attention of Arlene Dickinson of Dragon's Den fame. This week, she posted to Facebook, quote, "I've been watching the unfolding debate over the notwithstanding clause and wanted to better understand what is going on and what's really at stake in Ottawa's Supreme Court challenge of the clause. At first, it looked to me like this was a fight for power between Ottawa and our provinces. But the more I've dug in, the more I've realized it's about something much bigger. And that's whether Canada has one constitution or 14 different ones. The clause was built into our charter in 1982 as a safety valve. It's an exceptional tool meant to balance provincial rights with federalism when needed. But what was supposed to be used rarely is becoming routine. Quebec used it for Bill 21, Saskatchewan used it for pronoun policies, and now other provinces are looking at it too. The 5-year renewal is meant to keep all governments accountable, but that's basically turned into a rubber stamp. And I believe that when rights can be suspended again and again, they stop being rights. They become privileges that only exist when it's politically convenient." That from Arlene Dickinson. Today, we're digging into this. So when Scott Moe posted about this last week, there were comments from people saying, make this make sense. So today, we're going to try and do that. We have some constitutional experts standing by to break it down for us. They come at it from very different perspectives. We also want to hear from you. Are provinces overusing the notwithstanding clause, and what is at stake? Call 1-800-716-2221 or email us bluesky@cbc.ca. We have two legal minds who have very different perspectives on this issue. Ken Roach is a professor of law at the University of Toronto. He's written extensively about the Charter of Rights and Freedoms. He is also the author of The Supreme Court on Trial, Judicial Activism on Democratic Dialogue. Kent, welcome to Blue Sky.
Good afternoon, Jenna.
And Jeffrey Sigalet is a director of the UBC Research Group for the Constitutional Law and an assistant professor of political studies at the University of BC's Okanagan campus. Welcome to Blue Sky.
Thank you so much for having me. Good morning from BC.
Okay. Yes, time change. You're still in morning time as we're into the afternoon. Okay, notwithstanding clause, it rears its head every few years. We have seen it come up in job action. We've seen it come up, as Arlene Dickinson mentioned, in Bill 21 in Quebec. We've seen it come up in Saskatchewan with pronoun policies. What is happening right now that is getting people talking about it again? Kent, I'll start with you.
Yes, well, I mean, there's going to be a case argued in the Supreme Court, and it's about Quebec's use of the notwithstanding clause. So it wanted to ban religious symbols, and it used the notwithstanding clause. Now, Saskatchewan is trying to have its case heard at the same time, which I think would actually make sense. So we may have a mega case in the Supreme Court. And I think, one issue will be, can the courts do anything when the legislature has used the notwithstanding clause? And, on one end, you could say, well, maybe the court should just ignore the use of the notwithstanding clause. That's not my position. On the other end, you might say, well, once the legislature has said we're going to do this, notwithstanding the charter, it just isn't the business of the courts. The courts should say, this isn't our business. That's not my position either.
What is your position?
Well, my position, I think, is quite similar to what the federal government is arguing. And it's, the Globe and Mail had an editorial today criticizing it, the federal position. And the federal position, as I understand it, is that the courts, although they cannot overcome the use of the notwithstanding clause, which is only there, and the charter is specific about this, for 5 years. It can be renewed after 5 years, but of course that dovetails with another part of the charter not subject to the notwithstanding clause, which requires a general election at least every 5 years. So my understanding is that the federal government is arguing that the court can make a declaration, a kind of almost a non-enforceable declaration, that yes, this does violate rights. Now that means that the law will still continue to operate for the 5 years, given that the legislature has used the Section 33 override. But I also think it means that us as citizens will at least know what the courts think about this law when it comes time to decide whether the government that used the override should be reelected.
So you see it as an opportunity for voters to take more of an interest and pay attention to what's going on with their government and then make a decision accordingly.
Yeah, I mean, I see it as part of the democratic dialogue, right? The democratic dialogue that where both courts and legislatures have. I don't think I go as far as Arlene Dickinson, which seems to suggest that, as in the United States, whatever the court says, should be final and supreme. I actually believe we should have both legislative activism and judicial activism. So that's how I square that circle, but not many people agree with me.
Okay, I want to be clear, Jeffrey, before I go to you. Our goal today is to speak as if no one understands this, because I think that we hear the notwithstanding clause come up in the news a lot. And if it doesn't affect you and you don't understand it, there's a very good chance that you tune out and don't ever engage with the process because it feels like it's too complicated. It's legalese. It's the Supreme Court. It's stuff that I don't understand. And today our goal is to really help people understand what's at stake here and what the notwithstanding clause does for the government and what the policy affects. I'm wondering, we've heard from Kent what his position is. Where do you stand on it?
Okay, well, I just want to say one thing, which is I think that the government of Canada surprised everyone last week with their factum, because they went even a little, they did make the argument that Kent made, but they also went a little further. They said that where the act is continually used and continually renewed, the courts might be able to step in and then say, no, that's enough. Even though the text clearly does not say anything about limiting the number of renewals. So that surprised even people who take Kent's view, who are good constitutional scholars that I may disagree with about things, but some of them were surprised that Canada was that aggressive. And I think one thing you can read into this is that Canada getting so aggressive in how it wants to understand the notwithstanding clause and saying that courts should put limits on it, even more substantive limits, tells you a lot. And the provinces all writing their own arguments in this big case, saying, no, they don't. Once the notwithstanding clause is used, that's our view of rights, of how the rights work. It's our turn to have our say about how the rights work. And if we lose the election and it's not renewed, then the courts can step back in. But until that happens, it's our turn and not the courts. The courts need to be silent about that. They were also arguing that this was settled in a case called Ford, where the court said that Section 33, the notwithstanding clause, has requirements of form, that it's only for 5 years. It has to be renewed after that time. You have to mention the sections it applies to and the law you use it in. But that just sort of gives you a sense of the federalism angle of this, I kind of started off with the Dragon's Den. I didn't watch Dragon's Den, so I don't know who she is, actually. I'm sorry.
It's okay. She's a venture capitalist based in Calgary.
So I apologize for not knowing who she is. And being a bad Canadian and not watching Dragon's Den, right? But I think, she was onto something in her start of the quote you read, that she said I thought it was this federalism struggle. Well, there's a really important aspect to that you can already see that the feds want to limit it, but the provinces want to protect it. Well, why is that? One reason is that the federal government controls appointments to our appellate courts. So the federal government can influence the direction of charter jurisprudence by appointing people whose legal philosophies they like to the court. And That doesn't mean that the courts are just completely the puppets of the federal government, but there's a really important aspect of that. And that and the notwithstanding clause, to understand its origins lie partly in the provinces. When they're renegotiating the Constitution, the provinces are suspicious of a Charter of Rights, partly because they know the courts interpreting it and interpreting how their laws relate to it are going to be appointed by another level of government. So an NDP premier of Saskatchewan, Alan Blakeney, who was educated in political theory at Oxford, he studied with Sir Isaiah Berlin, he was a really smart guy, and a conservative premier, Peter Lougheed, both really advocated for the notwithstanding clause as a kind of balance, as you said, to ensure that provinces would be able to enact laws disagreeing with federally appointed courts about these really controversial rights questions. And so to understand the notwithstanding clause's significance, you need to understand that federalism angle. It doesn't mean the clause will never be used by the federal government. Pierre Poilievre actually promised to use it in criminal justice areas in the last federal election, but it's never been used by the federal government, the federal parliament. It's technically used by the parliament, not the government, right? But it's never been used at the federal level, and there's a reason for that. And it partly relates to this structural nature of the problem. One of the reasons why it was included, it was a demand of the provinces. And one more thing I want to say is that when we talk about the language of a safety valve, or it being this exceptional use, people will often say, oh, well, Jean Chrétien said that when the charter was introduced. He said this was a safety valve, it's for exceptional circumstances. Well, what they don't note is that Jean Chrétien opposed introducing the notwithstanding clause into the Constitution. He agreed to it as a compromise with the provinces. So we're trusting the wolf with the key to the chicken coop there, right? Like he didn't want Section 33. And then he characterized it as this thing that should be exceptionally used only in these special circumstances. But that's Alan Blakeney's not having any of that in his description of what was going on and what he was thinking. Peter Lougheed later in his life actually became a little softer on the notwithstanding clause and thought maybe we should even have some limits. But interestingly, in some of Lougheed's reflections, he's like, well, maybe we should not use it preemptively. But if the courts ever read the right to strike in, then we were prepared to use it. We would absolutely use it. And lo and behold, after a few years later, after Lougheed wrote that, the courts read the right to strike into the charter.
Historically speaking, I mean, we're 40-ish years into this safety valve, as we call it, but we've heard so much about it in the last 5-6 years. Why is that, do you think, Kent, that we're hearing more about it now and we didn't when it was, agreed to as that compromise then?
No, well, I think some of it, to pick up on what Jeff said about the preemptive use of the override. I mean, to unpack that, for example, Quebec used the override as a way of protesting. René Lévesque's government didn't sign on to the charter. But I remember when I was clerking at the Supreme Court, we came out with the sign language case. And I was visiting relatives in Quebec, and I left Ottawa thinking, what the Supreme Court said was reasonable. And by the time I got to Montreal and there was a bomb threat on the metro, I kind of knew that Quebec wasn't going to kind of accept this. So then Quebec used the override to say you could require French-only signs, right? And I think, everyone knew that it was Quebec saying we don't agree with the Supreme Court. But at least people had the benefit of the Supreme Court decision, which was saying, look, protecting the French language is a legitimate objective, but it's a little bit heavy-handed to ban all languages other than French. I think what we're seeing, and we see this in Saskatchewan, we saw it in Ontario with Doug Ford's government, we're seeing it with Daniel Smith, who wants to do it on gender affirmation, is we're seeing governments say, we don't even want to hear from the courts, right? Because they know that the courts, especially when it comes to the rights of people that may be unpopular, may be in the minority, they just want to use the override clause and they want to silence the court. Now, the Quebec Court of Appeal has said in a case where many people in Quebec see the secularism as basically a veiled attack against Muslim women who wear religious garb, that they can't be teachers, they can't, the Quebec Court of Appeal has said once the notwithstanding clause is used, the courts are silent. The Saskatchewan Court of Appeal, more recently, and I think correctly, with only 1 of 5 judges dissenting, said no. The courts can make a non-enforceable declaration, not that they necessarily would. And my argument would be, if we haven't had the advantage of a judicial decision, let's put that out into the democratic dialogue. Right. And so I think that that's why we're seeing it, is that governments don't want to actually confront judicial decisions. They want to silence the court. And I think in a democracy, we don't want to silence the courts.
Jeff, what's your response to that?
My response is that there's a lot of focus, so can't just focused on the legislatures and what their desires to quiet the courts. There's not a lot of focus on what's been happening in the courts. And since 2010, the invalidation rate of how a percentage of cases that the Supreme Court hears of provincial laws has skyrocketed and gone up. And so the provinces increasingly know that they won't win at the Supreme Court on the charter. And so they're more willing to use the notwithstanding clause to prevent their laws from going up there where they think they might lose. And that's not necessarily any kind of attempt to silence the courts. It's a matter of the legislatures prudently thinking they know what the courts might say about some of these things, and they think it's not right. They disagree with it. A lot of the times, too, the courts have already made it perfectly clear about what they think about the various issues, and the legislature is anticipating that, responding to that already. So it's kind of a mischaracterization sometimes to say it's a preemptive use when there's a clear precedent that the legislature is disagreeing with, right? That's still dialogue.
Well, yeah, but I mean, I'm not sure that we know for sure what the Supreme Court would say about either of the big cases that are going to be before it, the gender identity issue in Saskatchewan or the secularism in Quebec. And so, I mean, what's the harm, right, of allowing the courts to make those rulings if Premier Legault and Premier Smith and Premier Moe are that sure that they're right, then why can't they compete with a judicial decision? Why are they so afraid of the courts? Because really their position is once we've used the sledgehammer of the override, courts go away, have nothing to say until we run for re-election. And, if people are confused about the override, then they can also be confused about the effects of some of the policies that are brought in with the override. So I would hope that a politician who has the courage of his or her convictions wouldn't try to silence. I mean, we don't try to silence critics. I mean, maybe south of the border, we try to silence critics, but why silence the courts?
Jeff, I guess my question for you, though, is how do they know they wouldn't win? Like, why wouldn't they win? How do they know that it's just easier to go this way versus going up against the court?
Well, let's look at the long haul. The long haul is that they tend to know that they won't do as well because they're not in control of appointing who's up there. And that's just a general, zooming out from any one individual case, right? And we're talking about a bunch of different cases with different political kinds of concerns, Quebec itself being quite distinct, right? The other thing going on, is that there is a bit of black letter law as a problem with Professor Roach's view, which is that the view that the court, and so this, I hope I don't lose anybody, so I'm trying to keep it really simple.
Please do.
The view that the court, but I think it is simple, the view that the court should have a say about the law once the notwithstanding clause is invoked involves saying something like the notwithstanding clause is itself unconstitutional or protects the unconstitutional law because it only protects the operation of the law. This is Professor Weber's argument, which, Ken, you're shaking your head, but that's the argument picked up. That's the argument picked up by the factum in the Attorney General of Canada's factum. And so maybe you disagree with that, but I think that that is the main way in which courts get to have a say about anything with the notwithstanding clause. And that is a problem because it's characterizing part of the Constitution as unconstitutional. But if it's using the Constitution, the notwithstanding clause is part of the Charter, a constitutional part of the Charter, then it by definition cannot be unconstitutional. And so what I think is happening here is there's a problem with that. There's a problem with treating one part of the Constitution like it's less than other parts. And then politically, I think there's two ways of thinking about the practical part of what Professor Roach is saying. I'm all for having informed dialogues about rights. And I think that is that's something, a point of agreement between us. But what I think is there's two problems with the courts making these declarations. One is that often the declarations about rights from the jurisprudential perspective can be confusing and limiting in terms of the kinds of reasons people are allowed to bring, the kind of evidence the court considers, or how the court considers the evidence, right? For example, in the trial court case in Alberta, where an injunction was put up against Alberta's law that did not invoke the notwithstanding clause on prohibiting puberty blockers being administered for gender-affirming care and whatnot, the court signaled that the trial court signaled that she didn't understand at least many of the arguments Alberta was making and wasn't aware of much of the evidence Alberta was marshaling about some of the new empirical claims about how some of these, there are medical problems with administering puberty blockers to youth that are undergoing gender dysphoria. And that even some of the things she repeated were disavowed by the legal counsel in the Supreme Court case, arguing against, where the counsel was arguing against Tennessee's law and saying, no, your justices, that there isn't a suicide epidemic or evidence of a suicide epidemic amongst these children with gender dysphoria. That is actually not a claim I can make in this court. And she kind of proceeded like that wasn't the case. So with those kinds of courts can misinform our dialogue too, and the notwithstanding clause is a tool for the courts to avoid that misinformation potentially.
Kent, I'm going to let you respond to that, but I also is not the job of lawyers on both sides to suss out that misinformation and provide relevant witnesses and evidence?
Sure, no, the courts get to make politically loaded judgment calls, and they may not have very different political values and judgments than the provinces, right?
Mm-hmm. Okay, well, I just want to step in here because we have a number of people listening, and I would like to be able to give people who are calling in an opportunity to have their say on this as well. And I feel like I could just listen to you talk for the next hour back and forth because you do have very differing views. Yes, Kent, you're saying just very, very quickly. I mean, look, courts get it wrong. I mean, that happens all the time. But Jenna, I think you're right. That's why we have an adversarial system. And I disagree that the court is saying that it's unconstitutional. They're making a non-binding declaration that this is an unreasonable violation of rights, if that's the decision. And the court itself may be divided. And so I think the picture that Jeff is painting is, frankly, a very American position. It's that the government will appoint, we have a Scalia litmus test, so they'll appoint judges that always go one way. I don't think that we're at that stage in Canada, and I hope that we never would. And yes, courts make non-binding declarations all the time. So, for example, in the Manitoba Métis case, the Manitoba Métis said we were supposed to get land at 1870, and the government did a really bad job. And the court said, well, we can't give you the land and we can't give you money because you're coming to court too late, but we're going to make a declaration that, the government didn't do a very good job. And then after that, because of that, there were treaties signed and self-government agreements. It didn't mean that people had to do it, but why silence the courts? And in the UK, for example, I mean, we don't have that particular provision in the Charter, but in the UK, courts can say, can make non-binding declarations that human rights have been violated. So it's in America where
you kind of know what the judge is going to decide before you appoint them. And the Americans say the court can only make decisions in real cases and controversies if they can actually coercively enforce their remedy. And so, part of the problem that I have about this concern about judicial activism, which was really started by the Reform Party, is it's a very American debate. And I think now, we can see quite clearly what the problems are south of the border. Some of us may feel more comfortable there, but most of us want to keep a system. And I think it's a Canadian system where, the courts have said, some things may be legal and enforceable. You can do things, but conventionally, you shouldn't do things.
Okay.
I think that's closer to the Canadian reality.
Okay. We have an email here from Gerald. It says, hello, my interpretation of the notwithstanding clause was the provinces say, notwithstanding of the charter rights, we do what we want. Oversimplified, yes, but that's what it appears to be from me. And Gerald sends us that from Chaplin. And on the line now, Burke is on the line, calling from his combine near Moose Jaw. Oh, we do appreciate a farmer during harvest. Hi, Burke, go ahead.
Awesome timing coming to a power pole. I'll try to do two, not run into anything.
Please don't.
For you guys that are dealing with the little small details of the overall thing, now that you brought it up, I love how the United States of America works, that the only reason why they're able to stay together is because they're apart. They have such wide-ranging views. Each state gets to do its own little thing. Do you like gun control to protect yourself? These states are for you. If you don't like guns, these states are for you. Do you like capital punishment? Do you hate capital punishment? And recently for the Supreme Court, that abortion is nothing federal, there are states that you can go for abortion, thumbs up or thumbs down. Now, if we trade that to the Canadian version, if you live in downtown Montreal, you want French as the number one language and nobody has guns. That will not fly in Alberta. We don't think the same. And if you have a paintbrush that's 3,000 miles wide, you're going to have a very divisive country. And to put it into perspective, you are not a tree. Move.
That's a point, Burke. We do think differently, not just from province to province, but not everybody in Alberta thinks the same way. Not everybody in Saskatchewan thinks the same way. And in such a diverse country where we have urban and rural, we see how that plays out in elections and the way people vote. I think it's a really interesting point. Jeff, I'll let you kind of respond to his thoughts there.
Amen. I agree. I'm glad you're having a good harvest too, from what I hear. That's good. I completely agree. His analysis fits very much with what I was saying about federalism, that there can be different rights regimes within Canada, and that's exactly what the notwithstanding clause was intended to make happen. It was intended to ensure that different parts of the country could enact different visions of how rights work, and that is what we're getting more of now, that we have a more aggressive Supreme Court using the Charter to centralize, nationalize, and more aggressively impose rights solutions across the country that different parts of the country may disagree with. Look at Alberta and Quebec. They're standing shoulder to shoulder defending the notwithstanding clause against Ottawa, despite both disagreeing with some aspects of each other's policies. Alberta does not agree with Quebec's view of religious freedom in Bill 21, and yet it defends Quebec's right to articulate a different vision of religious freedom from that which is in play and protected in other parts of the country and in Alberta. And I think that's a great liberal democratic thing. I think federalism is itself a kind of instrument of rights protection that we forget about. It's a very, very Canadian instrument, too, that's been with us since 1867 and not just since 1982.
If you have thoughts on this today, we'd love to hear from you. 1-800-716-2221. That's 1-800-716-2221. Or send us an email, bluesky@cbc.ca. My question to you, Jeff, though, is if each province is intended to govern in its own way, why haven't we seen it done more often than now? And why with such politically charged changes when it comes to secularism, when it comes to pronouns, when it comes to transgender? Why are these the first things that we're really seeing come up as the big issues, even in just the last 5 years?
So one part, so I have a Canadian Journal Political Science article with Dave Snow arguing that the empirical, forget norms, what's right or wrong. What's empirically happening here? Well, I think there's two basic ingredients. One is that the court is invalidating more provincial laws since 2010, and that necessarily has a kind of centralizing effect. There's these decisions that are seen as activist by provinces because, in many cases, because they're invading their jurisdiction, saying, this is the right standard that applies across the country. So provinces, you can't have your own view about these things anymore. Provinces are more likely now to lose at the Supreme Court since 2010. The second thing happening is something we're all aware of, partisan division between conservative style parties or right of center parties of various stripes across the provinces, and a very aggressive federal liberal government that's been fighting the provinces on federalism issues, and also appointing justices who have a very different set of social priorities than many of the conservative-controlled provincial governments and their voters often, right? So you have this clash over federalism happening at the same time that the provinces are seeing they're losing at the Supreme Court of Canada. And so the province's new logic is, well, we got to use the notwithstanding clause to win. We can't just rely on thinking the courts are going to be fair to us anymore. And that has put pressure on them to do this. And you'll notice in the press a lot, and somewhat in Professor Roach's statements, although, I would say his view is much more fair and even-handed than, say, Andrew Coyne's. But you see Andrew Coyne saying, this is the fault of the provinces. They're controlled by populists who hate rights. But that's completely missing this other aspect of why are the provinces being pushed to do this? And one thing going on there is that it's the relationship between the court and the relationship between the federal government influencing what's empirically going on and motivating these very different conservative provincial parties to use the clause to get their view about rights issues across.
Kent, I would ask you the same question because I'm interested in your view.
Yeah.
Why now? Why politically charged issues? And are we overusing it?
Yeah. No, look, I think Jeff's right that there is, this kind of conflict, right? But I also want to come back to the point, and it was the, person out in his combine, my position, and I don't think it's even the federal government's position, but certainly my position is not that we shouldn't have Section 33. I've always been a supporter of Section 33. There are some people that are now saying, oh my goodness, we should take Section 33 out. I mean, that was Brian Mulroney's position at one point. So, we can still have federal diversity, but should we at least listen to what a court, and even, yes, the Supreme Court of Canada, which does exist in Ottawa, although it does have regional representation, should we not even listen to what the Supreme Court says? So I think that, yes, there is this tension, and maybe that explains the conservative, more liberal tension, may explain the use of the notwithstanding. But I come back to the fact that if you are a genuine social conservative, are your views so fragile that you think that the populace is going to turn on you if a court says, you're being a bit unfair to that minority, or you're ganging up on that unpopular person, or maybe there's not a rational connection, right? Maybe there's a way to do this to achieve the same objective, but with violating rights less. I mean, the legislature still, has the last word until the 5 years expires. But I think it's also the fact that some of the premiers, life is just easier if you don't have critics.
Jeff, do you think we're overusing it?
I don't think so. Look at the empirics. It's 6 times, 6 laws fully enacted since 2018. Probably going to be 7 now. Alberta will invoke it to protect its laws. So that doesn't seem like overuse. That seems like a spike that is explained by the phenomena I just talked about, right? And so when people talk about its overuse, I mean, Quebec's been using it a lot ever since 1982, even post-omnibus use, even when it used it to just protest basically Quebec applied it to all of its laws. They reenacted all of their laws of notwithstanding clause because they never signed the charter, right? So that was their protest that that happened before the famous case Ken was talking about. But to me, we've had Quebec continually using it on, including for very progressive ends. So protecting pension schemes that favor women in different ways. They've used the clause for that kind of end. And no one was talking about its overuse then. It's just that that is spread across the provinces as all of the provinces have started to see their laws get struck down at higher rates at the Supreme Court. And they found themselves tussling with a federal government that seems intent on imposing a kind of centralizing progressive will on the rest of the country across a number of issues, not just in federalism issues, but in or a straightforwardly division of powers case, as we call them in constitutional law, but also in rights cases. So the federal government's openly cheering for limits on the notwithstanding clause. But former Prime Minister Justin Trudeau was talking about very, I think, irresponsibly about sending a reference to the court to have them limited. That's kind of talking like the Supreme Court's his dog in the fight, right? That's not healthy in our federation, and it has resulted this clash over Section 33 itself has potentially reignited and reinvigorated feelings about separatism in Quebec. Although we'll see if that really manifests itself. It's just certainly reinvigorated a kind of nationalism.
We did have a conversation yesterday on the show, which I realize you being in, Vancouver and Toronto, you probably didn't listen to. But we had a conversation about Mark Carney and how he's done in the last 6 months and how different his approach is with the Federation and with the provinces. Do you think that if given another year, that you would see the same division with a different prime minister?
Well, we're getting a little bit off the notwithstanding clause, but that's, okay. But I've been following Danielle Smith and some of the things that she's saying. And, I'm starting to worry about Alberta separatism. I think she's really kind of pushing that. And, Jeff's right that it's not only they want to get rid of the Supreme Court, they want to get rid of the Canadian Pension Plan, they want to get rid of the RCMP, they really want a firewall. That's something that I take seriously, right? I don't think just because we live in Toronto, we should be able to ignore the West. I think that, in some ways, if we go back to the Charter, right, why did Pierre Trudeau, the first Trudeau, think that the Charter was important? I think it was because he lived in Duplessis, Quebec, and that was a pretty repressive place. Pierre Trudeau could not get a full-time job as a law professor because the premier signed off on it. So the way I describe it to my students, Duplessis was Trump before Trump. And I think that one of the things that Pierre Trudeau knew is that sometimes on some issues, you got to get out of the hotbed of your community and at least get another perspective on it. And so for him, he was willing to give up a lot on the Charter. He gave up Section 33. He was opposed to Section 33, just completely right, that it was Lougheed and Alan Blakeney that were the real founders. And I've said it was kind of a stroke of genius that even they came up. But I think Trudeau knew that sometimes you need another kind of perspective. And I guess what I worry about is if we say the courts are silent, are we just going to say, well, we don't care what people in Ottawa say? We're from Alberta, we're from Saskatchewan, we're different, and to me, that kind of results in that kind of division that we're seeing south of the border. Federal differences are important to me. I'm much more of a Brian Dixon than a Bora Laskin person when it comes to federalism.
Another thing we have in common.
But I also think that we need to listen to everyone. We need to take our time, right? I mean, one of the things that litigation over Section 33 does is it slows it up, and it allows us, us, not just the judges, the people, the legislatures, to think it through. Again, I think when we look south of the border, we see that if we do things instantly, if we go on Truth Social to say, okay, well, I don't like this judge is a Democratic judge or a liberal judge, and we're going to get rid of, we don't have to listen to that. So I guess what I would ask is that people that support the use of the notwithstanding, and people that oppose it, we need to have a deliberate and civil dialogue. It can't just be an argument that I don't want to listen to you, or you're violating rights and you're awful. I mean, we need to keep this conversation, this democratic dialogue going. And I think it needs to be as nuanced as possible. And I think the most nuanced debate is when, someone like René Lévesque gets up on his feet in the legislature and says, this is why we're using the notwithstanding clause. And the Supreme Court, say in the signs language, goes through a whole decision and says, look, we understand that the French language is under threat in North America, but we think you're a little heavy-handed here. Right. And, Quebec won that. But, one of the interesting things is when Quebec used that override, they didn't renew it after 5 years. They had sober second thoughts. Mm-hmm. And during those 5 years, some of the Anglophone merchants in Quebec went to the United Nations, and the United Nations didn't have power to enforce it. Right.
Okay.
But again, I worry that the next step is we're going to use the notwithstanding clause, and, we don't want the United Nations. Who's the United Nations to say what's law in Quebec or Alberta or Saskatchewan? So I worry about this authoritarianism, and I like diffuse, messy, complicated issues.
Yes.
And I think having the courts do it.
I hate interrupting you, but I really want to get to our next caller, and we only have a few minutes left in the show. Cheryl is calling in from Regina. Cheryl, go ahead.
Okay, thank you. I just wanted to emphasize the fact that the whole reason the Charter of Rights and Freedoms exists is to protect minority groups from what was, in quotation marks, the tyranny of the majority, right? That rights are protected so that you can't have oppressive actions against or negative actions against particular groups in our country. So the fact that some of the provinces are preemptively invoking Section 33, to me, seems like they're admitting that they are violating the rights of a particular group before it even goes through the court system. And I think that's what's problematic, not so much the use of Section 33, but I guess so my question would be if those on the line would think that there are actual examples. I'm not sure what example Blakeney had in mind when they argued for Section 33, but are there some legitimate? When is it legitimate for the majority to decide that it is okay to violate the rights of the minority?
That's a great question, Cheryl. Thanks for that. Jeff, do you have your finger up like you want to speak? I want to preface this with, I'm giving you 2 minutes because we're almost up on the end of the show.
I'm going to be very quick. And so I wanted to say that that's right, that the Charter is a kind of counter-majoritarian instrument in a way, but it's also this centralizing instrument that one majority level of government gets to appoint justices that may share its views and tend to have its values about these highly contested rights questions. So when we're talking about even some of these really controversial issues, right, like trans rights and pronouns and stuff like that, right? In those cases, there's people on both sides that think they're protecting vulnerable people. Both sides think they're protecting vulnerable children, right? It's not one side's on the minority side and the other side's not. They're perfectly nice, reasonable people in my family who disagree on both sides of that issue. And the Charter doesn't settle it. The Charter is abstract. It talks about security of person. Lawyers are going to bring in arguments with different kinds of social science evidence saying there's this threatened security person, this doesn't. It's all very, very contestable and involves contested value judgments. So when the notwithstanding clause is used preemptively sometimes, it's because it's even possible for the courts to enter this on one side of a contested good faith rights disagreement in a way that even distorts it. Because one thing that can happen is if the courts, even if they have their supposedly innocent say, like Professor Roche thinks they do, and I think that's it's improper constitutional law to say that they could do that. But even if they did have the say on it, then one side can then take that and actually short circuit the good faith debate and say, well, the courts say it's violating the charter. And they can just say, well, you're against the Constitution, you're against the charter, rather than engaging the other side and saying, no, this is why I think it protects minorities, and this is why I think your view of how it protects minorities or this vulnerable group is wrong.
So what I'm hearing from both of you is that we need more conversation and less people shutting down and just saying this is right or wrong.
Yeah, and you know, particularly, I would say, look, when, as in the Signs case, you have the court saying this is an unjustifiable violation, and the legislature is then, after that court decision, prepared to say, no, we think the rights of the Francophone majority are more important than the rights of the Anglophone minority. And, you know, my people are Anglophones from Quebec. I think that that's probably as fair as we're going to get under the charter. But I agree with the caller that if you use it preemptively before the courts have weighed in, then the legislature is not only silencing the courts, but I think more importantly, silencing debate.
Oh, go on. I was just going to say, this has been such a fascinating conversation. I just appreciate both that you can agree and disagree. And I think that that's what we need more of. And what I'm hearing from both of you in conversations around court, around rights, around all of these things is that we need to talk and we need to understand each other better and to understand where we're coming from and why we are standing on the sides of the fence that we are. And I just want to thank you both for making your arguments and for sharing your expertise with us today. I have so appreciated it.
Well, thanks a lot, Sam. It's been a pleasure. Good to see you, Jeff.
All right. That was Kent Roach. He's a professor of law at the University of Toronto. Jeffrey Sigalet is a director of UBC Research Group for Constitutional Law and associate professor of political science at the University of BC's Okanagan campus.